Good afternoon, everyone. So it's my great honor and pleasure to welcome you to the 2025 Boston University School of Law Max M. Shapiro Lecture. When BU Law alumnus Max Shapiro from the class of 1933 passed away, his son, Andrew Shapiro, class of 1977, his daughter, Sue Ellen Cadis, and his son-in-law, Larry Cadis, established a fund for an annual lecture at the law school in his name. And thanks to the great generosity of the Shapiro family, who I'm delighted to say are here with us today, if you could stand up. Thanks to their generosity, each year, this lecture brings to our community an individual whose work exemplifies the highest ideals of our profession: intellectual rigor, moral courage, and an unshakable commitment to justice. And I can think of no one who embodies these qualities more fully than today's distinguished guest, Associate Justice of the Supreme Court of the United States, Sonia Sotomayor. So it goes without saying that Justice Sotomayor's presence here is a true honor for our entire BU Law community. She has long been an inspiration to me personally, as I know that she's been to so many of you, and as you've just shown, we deeply admire her remarkable achievements, and even more so, we stand in awe of the grace, strength, and humility with which she has lived her life. The daughter of Puerto Rican parents, she was raised in the South Bronx by her mother and beloved grandmother after the loss of her father when she was just 9 years old, a year after she'd been diagnosed with type 1 diabetes. But these early challenges helped her to draw strength, and she found within herself a well of resilience and deep sense of purpose. Despite the hardships she faced as a child, Justice Sotomayor's drive and determination to excel carried her from the Bronx, where she was valedictorian of her class at Cardinal Spellman High School, to Princeton University, where she graduated summa cum laude and received the Pine Prize, Princeton's highest undergraduate honor, and then on to Yale Law School, where she served as editor of the Yale Law Journal. From there, she built a remarkable career. She began as an assistant district attorney in the New York County District Attorney's Office, where she would spend nearly every workday for 5 years in the courtroom, prosecuting cases of murder, robbery, childhood abuse, drug trafficking, police misconduct, and fraud. In 1984, she joined the law firm of Pavia and Harcourt, where she acquired expertise in trademark and intellectual property litigation and advanced from associate to partner. In 1991, she was nominated by President George H.W. Bush to the U.S. District Court for the Southern District of New York and became the first Latina federal judge in New York State and the first Puerto Rican woman to serve as a judge in the U.S. federal court. In 1997, President Bill Clinton nominated her to the U.S. Court of Appeals for the Second Circuit. And in 2009, President Barack Obama nominated her to the Supreme Court of the United States, where she replaced Justice Souter as the only justice with experience as a trial judge, and made history as the first Latina and the first woman of color to serve on our nation's highest court. And if this were not enough for me to fangirl about, for all of us to fangirl about, Justice Sotomayor is also a best-selling author, known in particular for her memoir, My Beloved World, and her recently published #1 best-selling children's book, Just Shine, How to Be a Better You, a story inspired by her mother, Selena, and her mother's ability to help the people around her see their own brilliance. We're all extremely grateful that Miss Selena Sotomayor helped her daughter to do just that. Through every chapter of her career, Justice Sotomayor has embodied courage, the courage to speak her truth, to champion fairness, and to see the humanity within the letter of the law. As a jurist, she is deeply attentive to the lived realities of those affected by the law, and particularly of those whose voices too often go unheard. Her writing is marked not only by its analytical precision, but also by a moral clarity that reminds us that behind every case, there are people whose lives and futures depend on how the law is understood and applied. Her opinions and dissents have become landmarks in their own right, rooted in constitutional fidelity and animated by compassion. She has been a powerful voice for equality and inclusion, a guardian of individual rights, and an unrelenting advocate for the idea that justice must serve everyone, not only those with privilege or power. As President Obama said when nominating her, Justice Sotomayor possesses, quote, a depth of experience and a breadth of perspective that will be invaluable as a Supreme Court justice, end quote. She has proven those words true many times over. This is a truly special moment for all of us here today, and especially for our students. I know it is a moment that our students will remember for a long time after they leave BU Law. And students, you have the distinct privilege to hear and learn from someone who has reached the pinnacle of the legal profession, but who remains deeply grounded in her values, in her community, and her calling to serve. Someone who has faced many obstacles and biases and transformed them into sources of insight and purpose. Someone who continues to remind all of us that where you start should never limit where you can go or what you can give back. Justice Sotomayor, we are deeply honored and incredibly grateful for your presence here today. Thank you for your extraordinary service to our nation, for the wisdom and integrity that you bring to the bench, and for the reminder to all of us, especially our students, that law can be a force for dignity, equity, and hope. I also want to take a special moment to thank our own distinguished alumnus, Cesar Lopez-Morales, of the VU Law class of 2014, who will be moderating this historic conversation. Cesar, as many of you know, was an outstanding student who excelled in the classroom and was deeply committed to public service. As a student at BU Law, he was senior editor of the Boston University International Law Journal, vice president of the International Law Society, and director of the Homer Albers Prize Moot Court competition. In fact, as a 2L, he and his moot court partner earned a coveted first-place victory in that competition. He went on to serve in 4 different prestigious federal clerkships, including the extraordinary honor of clerking for Justice Sotomayor. He previously served as an attorney in the U.S. Department of Justice's Civil Division Federal Programs Branch. Today, he is counsel in the Supreme Court and appellate group at Orrick, Harrington, and Sutcliffe, handling high-stakes appeals across the country. And we like to think that he got a start as a star appellate litigator here with the Albers competition. Cesar, we are so proud of you, and we are so proud to have you back with us, and we look forward to a time when we can invite you back as a first BU Law graduate to serve as a justice on the U.S. Supreme Court. Before I announce justice, I want to make it clear that there are no photos to be taken during this program. And so now, without further ado, please join me in giving a very warm BU Law welcome to Associate Justice Sonia Sotomayor.
Hello.
Hello, Justice.
He said he was a little nervous.
Just a little bit. I told her I don't do this every day. But thank you, Dean. And I could not be happier to be here with all of you and share this very special moment. The Dean talked about how you students and everyone in here will remember this great event with the Justice many years later. And I have to say, when I was in law school, I believe it was 2012 or 2013, I attended a very similar event when Justice Breyer was the speaker. And so I remember that very vividly. And when I was sitting, it was at the BU Law Auditorium, but as a student, if someone would have told me that years later I would be in this position as a former Supreme Court clerk and moderating an event with no other than the great Justice Sotomayor, I would have been, are you crazy? What are you talking about? And
So I want that for all of you. Now, before we start talking, I hope that every student in this room, and I know the first year class is here, which I'm very touched by, and I know you created a lot of jealousy with the upperclassmen, okay? But I'm glad you came, because I hope at the end of the evening you come away excited about becoming lawyers. I actually think and feel that it is the best profession anyone could become. Why? Because we are the only profession of all that has as one of its ethical obligations to serve the poor without charge. Think of doctors. They take the Hippocratic Oath to do no harm, but they don't say they'll do it without cost. And as you know, they don't do it without cost. Most of them, some of them. Like Cesar's wife does it for little. But lawyers, day in and day out, in all aspects of our profession, from corporate law to DOJ, to federal defenders, to legal service organizations, undertake to help the disadvantaged in our society. And even when you're working as a corporate lawyer the way Cesar is, you can still devote time, as do many of the people I admire greatly, to serving those in need. And lawyers do the work of those who can't speak for themselves. I loved being a lawyer. I've loved, maybe not right now as much, but I've loved being a judge. Stay in the profession always motivated by remembering that you can do good. In any job you take in law, you can still do good. And so I hope you become and stay as excited as I am about becoming lawyers.
well, that's great, Justice, because that's a perfect segue to my first question.
We didn't plan this.
No, we did not, no. Which, I mean, in every step of your career, you've made it a point to not only display your brilliant intellect and rigorous analysis, but just care about the lives of ordinary people. And you do that in every of your decisions. You did that as an advocate. And so can you tell us a little bit about that process and deciding that you wanted to be a lawyer and eventually a judge, and what went into that decision-making and influenced you?
There's a lot of fun stories. I got to keep them brief, or I'll take up the hour with you, okay? I didn't start with that as my motivator, okay? I started with Nancy Drew, who was a detective. And I loved reading Nancy Drew. A lot of the young people here probably don't know her, but it was the first chapter book I read. And my age, she was famous, okay? At any rate, she was a neighborhood teenage detective, and she solved neighborhood problems. And she had a father who was a lawyer, so that's the first I read about somebody being a lawyer. And she'd go and seek some legal advice from him. But it was really playing detective and helping the people in our neighborhood solve mysteries that I became enamored of. And I wanted to be a detective when I grew up. Then I got diabetes, and at the time they told me that I couldn't go into law enforcement. And there's still some arms of law enforcement that you can't join as a juvenile diabetic. And as only a youngster could do in great melodrama, what am I going to do with my life now? And then I found Perry Mason, the first TV lawyer, okay? And Perry Mason made me realize, the first half of the show was investigating the crime his client was charged with, and the second half was going in the courtroom and getting someone to confess they did the crime, not his client. That second part has never happened. But I sort of, and only the way a child could, realize that I could play detective as a lawyer. And in some ways, that's what we do. We put together puzzles. We take clues from case law, from facts, from situations, and we put them together into an argument. And we put that argument to either a judge, and when then you're a judge, you get the arguments and you put them into a cohesive doctrine, and you try to make sense of them. So there really is that intellectual part of law, which is the way my mind works, which is bits of pieces and puzzles and putting things together. But what led me to law? It's when I began to realize as I was growing that what law is about is helping people in their relationships. And what brought that to life was a question my niece asked me. She was about 8 years old. She was little. And I went to visit her in Syracuse, and we were sitting down, and she said, "Titi, Daddy takes care of wheezers and sneezers." He's an allergist, okay? Mommy takes care of sick babies. Mommy is an ICU nurse. Grandma takes care of sick adults. My mother was a nurse. Omar, my mother's husband, takes care of sick cars. He was an auto mechanic. What do you take care of? And that question put into focus why I became a lawyer. Because I help people in their relationships with one another. When they can't get along, and they can't find an answer together, they come to a lawyer and then a judge. When they want to have a relationship with one another and make it better, make it work better, they come to lawyers to sign contracts, to make wills, to help figure out how to make their relationship with one another function better. And that's what lawyers are there to do. You're there to represent a client, but for what purpose? And the purpose is to help their life in the situation they find themselves in. And if it's in court, it's in conflict, and you're trying to resolve that conflict or help them resolve it. And if it's transactional, as most lawyers do transactional work, it's to help them in some aspect of their life with others. And if you focus in on that as what the purpose of law is, then you don't lose sight of the people. And so for me, from the very beginning of my deciding to become a lawyer, it was focused on what we are doing is making societal judgments about how to organize our existence together. And if you don't focus on the people and lose sight of that, then the enterprise has no purpose. Because the enterprise is like moving little blocks around. And you always have to be cognizant of where those blocks are going and how they fit together with whom? With the people who are being affected. And so I think if you read my decisions, you already see that. You see that I never ignore precedent. I never ignore the statute. Nobody does anymore. You have to start with the language. You go through the precedent and how it's interpreted and how it's been applied, and you do all the legal steps. But at the end, you have to remember, how does that fit in with our relationships with one another? How is society interacting with that individual? And is it fair, not in a moral sense, but in a constitutional sense? What are the values we have as a nation? How have we expressed those values in our Constitution? And what is the purpose of law, if not to serve people?
And so, Justice, let me ask you about your writing process, because I mean, not your colleagues in the court may not have the same process and may not.
Everybody has a different process.
And may not be thinking about these things, right, when they're writing opinions, and so you write opinions for the court, you write a lot of dissents and concurring
Too
opinions. And so can you tell us about the process, and in particular, when you think about the audience, like each opinion has a different audience, and how
It does.
Right.
It does. People are always asking me, and they'll load the question with, are you writing for future generations when you write a dissent? And I go, no, it depends on the case. I mean, some constitutional cases are for the future, because my court has decided something wrong, and I'm sort of telling them. And telling them and asking future generations of judges to look at the issue and see it from a different perspective, and hope that I will convince them that that perspective was more compelling. I'm also counting on, because that's why people change, why courts change decisions, I'm praying that I'll be proven wrong. Because generally when I'm writing a dissent, I'm telling my colleagues, you're messing this up badly. And I'm predicting the ways in which they're messing things up and the damage they're causing. And experience is the greatest of life's teachers, and that's how change has always happened. So you think of Brown versus Board of Education, it took too long for my court to get it. That separate but equal was not separate but equal. It was separate and unequal, okay? And even when you don't have separate but equal, reaching equality is not a simple task. But it took us too long to figure that out and undo Plessy versus Ferguson. But the law learns, and there's plenty of precedent that I've joined overturning it, because experience has taught that it didn't work. Now, sometimes precedent doesn't work because the underlying assumptions are wrong. And so there's a lot of economic decisions that the court has overturned because it realized that the market didn't operate in the way it thought. So it rendered those decisions on falsehoods. And those are easier to overturn because markets adapt to changes, okay? But others are the cases that I'm dissenting in now. I'm praying for one of them to be sooner rather than later, presidential immunity. I'm writing to set the groundwork for a court not too far in the future to look at what I said and say, you were right, Justice Sotomayor, they were lawless. Sorry. Shouldn't be so harsh, should I? No, I mean, presidential immunity, in my judgment, was a made-up doctrine because the Constitution presumes the president can be convicted after an impeachment. The question was, can he be convicted without one? And the Constitution says doesn't say anything about that. And our founding fathers actually debated that issue and consciously chose not to give him immunity in the Constitution. So there were a lot of reasons, historical and otherwise, that I use. So I'm hoping a court will sooner rather than later see the error of its ways. But those are only a subset of the court's cases. Those big constitutional cases, assume we hear 56 a year, we're not deciding more than about 6 of those in any given year, and sometimes just 1 or 2. So the vast majority of cases are not constitutional cases. They are statutory interpretation cases. They are interpretations or refinements of our own doctrines and how to apply it. And in those cases, my audience can be very different, and it often is. The first question I asked, and you'll remember this as a law clerk, who are we writing for and what's our purpose in writing? Because you always have to have a purpose. In everything you do in life, everything you do as a lawyer, your first question should always be, what's my purpose in doing this act? And does this act accomplish what I want? The third question is, what's the downside of the way I've chosen to do it? Is the downside worth it? Is there a better way with less downsides? Only once you've gone through those steps should you ever decide something. So my first step is, who am I writing this for? And I identify that audience. Sometimes it could be lower court judges. And the court is saying that the lower court judge did not abuse his or her discretion. And I think, well, I'm saying they didn't abuse it, but I think they should have thought of more. And I'm writing for those judges to think about what I said, to put it in their calculus. And often because I believe once they add that to their calculus, that it's going to change the minds of some of them. And it does. There are decisions that come back up that I see judges have applied what I've said, and they got it. They got the message, okay? Other times, the message is directed to a legislature, whether it's the state or the federal. Congress, the court's messed up. You fix it, please. The most famous recent example of that was Ruth Bader Ginsburg, Betsy Ledbetter case on the Equal Pay Act, where she wrote that the court's ruling was fundamentally unfair, that we did not permit women who had been discriminated against for years in unequal pay from recovering for that difference, because we said our statute of limitations was limited to 3 years only, and not till the time that they discovered the injury. So we said it was only 3 years. Well, President Obama's first legislation that he signed was the Betsy Ledbetter case, bill that changed that statute of limitations, okay? So that dissent had a great impact on legislation. Others is to executive agents, like states, and saying to states, we're doing this, but there's a reason why we might be wrong. You don't follow us. Take your own path. And there have been states that have done that on dissents that I've written. Sometimes it's executive agencies themselves where I say, my court is giving you permission to do this, but maybe you should rethink it because there's a downside to what you're doing. And I've had situations where the agency has reversed its decision. So you have to always ask that first question. Who am I writing for and what's my purpose?
And I would say, Justice, that has been one of the biggest lessons of the clerkship, and you know, growing as an advocate, I've learned that to be effective, you really have to know who's your audience and who are you talking to, whether it's writing or arguing or advising a client, whatnot. Mm-hmm. And so that's something I learned during the clerkship. And I know there are a lot of students here who are interested in clerking, and
they want to know how they
want to know. They want to know what do you have to say, what's your advice, and more importantly, why are clerkships important? Why is this something that students should pursue if they have the chance?
It's my greatest professional mistake that I didn't clerk. Now I say that with tongue in cheek because I'm on the Supreme Court. So it wasn't a fatal error, you know, okay. But it was a really bad judgment on my part. My mentor at the time did recommend I clerk, and I didn't ask the right questions as to why I should clerk. He just said to me, it's important for your career, and I didn't probe further. So I'm going to tell you what I wish I had known. It wasn't like I thought, a low-paying job that you spent the entire time in the library. You do spend a huge amount of time, no longer in the library, on the computer. Back then it was in the library. But the really valuable parts of a clerkship are the mentorship relationship that you develop with someone who's been in the profession and who teaches you how to think about law and how to apply it. And it's something that you learn in practice, but it takes you years to figure it out in practice on your own. In 1 year of clerkship, you're going to have the equivalent of 4 to 8 years in practice in learning what arguments convince you and the judge. How are the cases presented? And you're not getting just the one partner that you're working with on one project. You're seeing dozens of motions flood in, dozens of papers of all kinds. You're seeing so many different styles, and you're figuring out what works, what doesn't work, what distracts, what helps someone focus. You improve your own writing dramatically once you see what works and doesn't work, all right? And you don't get that exposure in the individual cases that you're prodding along in as a practitioner. You see it because you're being presented with the flood of cases that come into a chambers. If you're lucky, and for most people, you can develop a relationship with a mentor who will be there by your side the rest of your career in a way that no one else is. Because in a law firm, you're not working for one partner, you're working for a pool of partners. They're all vying for your attention. You go to a clerkship, you're working with one lawyer, and he or she is generally committed to you and developing you as a lawyer. And there is no other part of the profession that really does that. And I think, finally, if you're going to be a litigator in particular, you get to see the styles of different people in court. And that's its own learning experience. Ted Wells, a very famous trial attorney in New York City who was at Paul Weiss and the head of its litigation department for decades. He's now retired from there. But Ted came to one of my classes when I was an adjunct professor and said that in his clerkship, he spent every minute in the courtroom that his judge was there. He stayed up all night to do his work, but that he started learning to be a litigator by spending every minute he had while he was a clerk in the courtroom. And I think you remember that I told my clerks, you come to oral argument. And I made them come. And I would say to you, whether you want to or not, it's the only opportunity you have to see all these different styles. So those are the practical reasons I didn't understand about clerking.
And we were going to stay up regardless, right?
Exactly. So you might as well have gotten something out of the day, you know. You can't get on the Supreme Court unless you've done a Court of Appeals clerkship. So that's step number one, okay? I don't think I have any of those colleagues on this court, but when I was on the Court of Appeals, some of my colleagues didn't hire people on the Court of Appeal who hadn't done a district court clerkship. I did half and half. I would hire a few students out of law school and always 1 or 2 people from a district court clerkship. So the higher you go, the more they're going to want the lower court clerkship. But every clerkship is valuable for the reasons I gave you, whether it's state or federal. It's important because they give you the things I spoke about, all right? What do you need to get a clerkship? Well, you need to write well, because every judge is looking at your writing sample. So you better figure out how to write well. It helps for a lot of places, especially the federal system, if you've been on a law journal, and if you have a officership in a law journal, it shows that you have leadership qualities that judges are going to look at and admire. You've got to do well in school. You got to work hard and get good grades. And you have to make mentors out of your professors. For me, a lot of the people I hire, I look at because someone I trust is recommending them to me. And I think that's true for virtually every judge. virtually, and there's a few exceptions to this, but most judges rely on people in schools whom they trust. And you can probably figure that out at BU and anywhere else by the professors who you know are feeders to judges. And so you do have to get some professor, better more than one, who are going to go to bat with you with a judge. And that helps the process as well.
So, Justice, we also have some questions from students, but I do want to ask one more question before we turn to the student questions. In more recent years, the U.S. Supreme Court has issued a number of opinions resulting in major changes in established legal doctrine, and we've talked about some of that. And of course, the reactions to those cases vary from individual to individual and even across communities. But many students are feeling discouraged or disillusioned with some of those recent decisions, and some have even questioned whether the law is the right path to follow. So what words of wisdom and hope do you have to offer to those students about the importance of lawyers and the power of law in our society?
If you're going to become a lawyer because you think you're going to win every case, quit law school. What lawyers do is represent the interest of people who have a problem, and of people often who don't have a chance and need a champion to stand up and be their voice against what their perceived injustice is. That's what lawyers do. Lawyers, and the very best of lawyers, fight losing causes. And do we have a right as a society, as America, to turn our back on law? Our founding fathers created a constitution because they believed that at the center of a civilized society and a government that they wanted to make work, that law and the rights it protected were at the center of that experiment. To say today as a young lawyer, or to say today as a citizen of this country, I hate politics, I'm going to walk away, is to be a bystander in life and let it roll over you. I refuse to be a bystander. I refuse to let any bus roll over me. I get up every morning ready to fight. Every morning to dissent as vehemently as I humanly can. To scream from the mountaintops, no. All right? They're not listening too much, but I'm going to keep doing it. That's what you become a lawyer to do. To fight for what's right. To fight for the law. To keep fighting even when you're knocked down. You know, think of someone like John Lewis, Selma, being beaten over the head over a peaceful demonstration. And he got up and kept fighting. Till the day he died, he was fighting to protect the rights that he thought were so important in America. And I just won't give up on my country. And so I tell every discouraged young lawyer, don't give up. Keep fighting for the America that is your country. Don't let it slide away from you. Don't let people knock you down. You know, then Vice President Biden said to me, he came to visit me during the nomination process when they were beating me up a lot. And he came to try to make me feel better. And he said to me, Sonia, my mother used to tell me, I measure your character not by the number of times you've been knocked down, but by the number of times you've gotten up to try again. And I measure my character that way. Because I get knocked down a lot, and I have throughout my life, but I never cry uncle, ever.
So maybe now it's a good opportunity, Justice, to turn to the student questions. And
Okay.
I'm happy to read from the questions, but maybe I'll ask if I read your name.
If he reads your
stand up.
name and you get up, I'm going to come down and take a picture with you. All right? So take advantage, the rest of you. My security always gets upset when I walk in the audience. They're not protecting me from you, they're protecting me from myself. All right? If you get up uninvited, they get upset, and then they whisk me away, okay? So don't upset them, stay seated. But if you call out your name, you've given permission to come up and come into the aisle so I can take a picture with you, okay? All right, go ahead.
Don't take it personal if I don't read your name.
Go ahead, sweetie.
So let me start with Sanjana and
Where do I start? This way is good.
Maya. Oh, great.
Who is she? Ay,
Sure.
qué bueno.
So they're both 1Ls, Justice.
All right.
And something incredible about the Justice is that even though she's walking around, she's listening to everything that's happening. So,
And that is sad. He knows me so well. Go ahead.
Justice, with so much at stake in each Supreme Court decision, how do you navigate personal or ideological differences with your colleagues on the court? And more broadly, in a time of heightened tensions, how do you remain a reasoned and principled voice on the court? And what advice would you give to young lawyers about fostering civic charity in this climate?
Oh, okay. Big question. I'm going to walk around so you can sit down, okay? Hello, you guys. I think I have to start at the very beginning. And the very beginning is my own mother. And you'll see some of her lessons. If you read my newest book, Just Shine, you'll hear some of those lessons. My mother had a friend who talked endlessly. She never stopped talking. And she would come to the house, and my brother and I would see her walk through the door. I would run to my room to read a book, and my brother would run out to the basketball court, because we couldn't stand her talking. I don't think she took a breath. One day, after she left, I looked at my mother and I said, I can hear her back there. How can you stand it? And my mother looked at me and said, Ay, Sonia, she can be a little frustrating, but, you know, she's such a good person. Whenever I've been sick, she's the first one at the door with food. She lived my mother didn't have a car, and she said, if I call her and tell her I need to go somewhere, she takes me. You know, she's lonely. She needs to talk. So I just listened. And I walked away from that conversation and realized that it was a very simple lesson, isn't it? And it's something I've taken to heart, which is, in everybody who annoys you or frustrates you, there's something good. You have to look for it sometimes. No, seriously, sometimes you do, okay? But people who have different ideas than you, people who act differently than you, people who are just different and frustrating, if you try to find the good in them, you're likely to find it. And once you find that, you can forgive a lot, and you can sort of live better with your frustrations. That's what I do on my court. I live with my colleagues in an incredibly friendly way. Cesar, I think I don't speak wrongly when I say I think most of my colleagues like me as a colleague.
And their law clerks.
And they like me. And they like me because I like them as people, even though I think they're crazy as judges. No, even though I disagree with them, even though I think they're wrong-headed, I can go on with a lot of adjectives, okay? And there are days I feel it, okay? But I am very conscious about the fact that they are human beings. And like me, every one of them is devoted to their families, to their spouses, to their children. Each one of them has had their own moments with their children. No one has perfect lives. Each one struggles. Every set of human beings struggles. They have charities that they devote a lot of time to. They have issues that are important to them that are not merely legal issues. Everybody is a human being. And you have to stop thinking that when somebody thinks something different than you do, that they're necessarily bad people because of that. And good people do bad things. Think about that. Think about those of you in this room who are parents, or when you become a parent. Your child is going to do something horrible, something stupid, something you don't like, but you don't stop loving them, do you? They're not bad people. And so that's how I tolerate my colleagues. And I do more than tolerate them. I live with them, and I have moments of laughter with them and moments of sadness, both personal and professional. You know, when they make decisions that I think that are misguided and that are horribly consequential, there are moments I'm angry, deeply angry. And other moments I'm deeply, deeply sad. But I also realize I have to live with them, you know? And I have to go on to the next case and the next battle and the next moment. And to do that, I have to hold on to the humanness of us as a group. And so that's what I do. So how do I center myself in a world where there's that much disagreement constantly, you know, and there's a lot of disagreement. I mean, being a voice in the room is important, and that helps me center myself there because I get to speak what I'm saying, what I'm thinking. But it's also understanding that, you know, there are always little victories. There's the individual cases that I do win, and they keep me going. So I look for glimmers of hope in every which way I can find it. So I answered the question, didn't I? Did I leave anything out?
You did.
Okay, go ahead.
So the next question is from Diego, who's also 1L.
Diego, ¿a dónde está? I'll come around. Hello, how are you? I walk back here because I know from here, I look tiny over there, don't I? So at least you get to really see me, and some of you I've met before.
So, Justice Sotomayor, as law students, many of us dream of arguing cases in front of the Supreme Court. What do you feel young lawyers can do now to set themselves up for becoming such an appellate attorney in the future? And what do you feel the most successful appellate attorneys who argue in your court do that is especially persuasive?
All right, I'm going to go down there, I'm going to come back up, and then I'm going to go up there at some point. All right. Let me start with the second question. Your greatest currency as a lawyer is your integrity. I cannot underscore that more. The minute that you mislead, that you taint, that's the end of you as a trustworthy advocate, and especially before a court. I have a lot of lawyers ask me, do judges talk about advocates when they go to lunch? And I tell them, I'm going to give you your greatest nightmare, yeah. If you flub it, we're going to talk about it. If you do a spectacular job, we'll talk about it. You know, we're human beings. But the best appellate lawyers or the best people who argue a case, whether appellate or even in the trial level, you know your record inside and out. There's nothing that you say that comes out of your mouth that isn't precisely in the record. You know, I did one of my first exercises in the DA's office during training, where I listened very carefully to the witness, and I did a mock cross-examination, where I realized what the witness wasn't saying. And what the witness wasn't saying was that she didn't really see something. She jumped a quantum leap and assumed a step, and I got her to look bad on this mock cross because she had given a direct that suggested she saw something she didn't. Well, that's the same way with someone who's arguing before court. If you're not very precise in saying, the record says this, and from that I draw this conclusion. When the judge goes back to the record, if it doesn't say this, the rest of your argument has gone out the window. Okay? So you have to take every piece of your argument, every piece of the cases you're relying upon. The worst thing to say when you walk into court, this case controls my issue completely. If it did, you wouldn't be in court. The other side wouldn't have an argument, right? They're obviously distinguishing it. So why are you making such a broad, unsupportable statement? You gotta be able, from every word you speak, to say to someone, this is why this case supports me. These are the principles of this case that I'm relying upon. And although the facts may be a little different, or this, you know, this is still controlling. So one of the best oral arguments that ever occurred was when I was on the Second Circuit. And on the Second Circuit, a defense attorney got up to argue his case. And one of my colleagues said to him, "Counselor, why isn't it that this wins the case for you?" And the lawyer's going, blah, 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 blah. Well, you're right, Judge. That's what I'm arguing. That's what I think, too. And he sat down, and I was about to say something when the time stopped. And the prosecutor got up and said, "Your Honor, when I first saw this case, I thought exactly the way you did. And I thought that I should win. But the problem is the Second Circuit has a case that says no." And he corrected the judge's impression. And he said, "But I can still win because of this reason." That was an inspired argument. For an adversary to think that he could win on the wrong argument, but he disavowed it because he knew that there was a controlling precedent. But then he jumped and said, "But this is why I'm arguing differently and why I win on my argument." And the second thing he did was one of my colleagues started reading a line from one of our cases and said, "Doesn't this hurt your argument?" And he said, "If that was the only line, it would, but the next line says this, and that's how I win." So when I said know your facts and your cases intimately, those are the best arguers. But what that shows you is the integrity you have to have. You cannot make an argument that's not supported. And if you're going to take a quantum leap, take the judges with you, but don't try to mislead them that this isn't new. You've got, your integrity is your highest coin. And without it, you will never be respected as a litigant. And people get, you know, even in New York City, and as big and as many lawyers there are in New York City, there's a lot that are repeat players. You appear before same judges all the time. And the bar is a much smaller place than you think, no matter the size of your city. As large as New York, a lot of the lawyers in New York know each other. And if they don't know of each other, they know of each other. Guard your reputation, okay? So what do you have to do as a young lawyer to get there? Learn the difference between a holding and dicta. Don't leave law school unless you can define what a holding is and what dicta is, okay? That's where you start. Because with that, then you know what precedent actually controls a case and what ill-said words you can dance around. You know, that's dicta, but you have to learn that difference. You have to learn precision in your writing. You have to, in answering exam questions, start thinking of what I talked about in terms of being precise as a lawyer and careful. Careful of what you're writing, careful of what you're spilling back to people. And number 3, even here, remember that you're starting your reputation. And I tell law students, even the ones who have worked for me as interns when they did, now they don't let me hire them, it's a long story. But for many, many years I hired interns, and I would say to them, the worst thing you could do is come intern for me, and I give you an assignment, and your term is ending, and you walk in and tell me I didn't get to this. Your reputation you must guard. And that must include your commitment to doing the work that you've promised to do on time. And so I tell them, you can tell me I can't take that assignment because I'm leaving in a week, and that I will never hold against you. But if you walk out the door of me expecting something and it's not done, that's it for you. And that's it for you. As a student, get involved in things, but don't get so overly involved that people can't count on you. Your reputation here is important. How you treat people here, the respect you hold for yourself here, that's what's going to make you a great lawyer someday. So start here.
Great. I was just thinking, this is, if you think about the clerkship, this was just every day, just listening to all the wisdom and the advice. I could just stop talking and listen to you all day. But I think we may have time for maybe one more question. So I'm going to call on Emily, who's an LLM student.
Where's Emily? Ah, you're right at the corner. Thank you. Thank you. What are you studying?
I'm actually doing my LLM in intellectual property.
Oh, how wonderful.
Yes.
You know, that was my field of expertise.
Exactly.
Oh, I'm facing Patricia, facing the wrong way.
Thank you.
Oh, wait, he's going to move that way anyway. Go ahead, Cesar.
Thank you so much.
So, Justice, Emily's question is, you have often spoken about the importance of your life experiences in shaping your perspective. And as you reflect on your tenure in the Supreme Court, could you share how a specific experience from before you were a judge that has unexpectedly informed your approach to a particular case or area of the law?
Oh, my God. Oh, I have to think about that. Hold on. Before, on the Supreme Court, they're asking.
Yes.
That's hard. That's hard. You know something? I don't want to answer that way, Cesar.
Yeah, I mean, you get to
And
decide,
I don't want to
Justice.
answer it that way because it involves more of my own internal deliberative process about a particular case.
Great, yeah.
But I can answer it a different way.
Please.
All right? I can answer it by showing examples that I'm aware of how life experiences have seemingly almost affected decision-making, okay? So I think of one of them, my being, and some of you heard this story before, I apologize, for those who've heard it before. In the Riley case, which is a cell phone case, one of my colleagues asked the defense attorney who was before him, who besides a drug dealer has 2 phones? And my immediate response was, the lawyer in front of you. This justice had been in DOJ and in government before cell phones. Now for you guys, that's your entire life. But that wasn't my entire life. Most of my practice didn't have cell phones, okay? Certainly not computers. I didn't start learning the computer till I became a judge. So for him, he wasn't used to having 2 phones, all right? And that assumption that only drug dealers have 2 phones was ridiculous. But that's one example of a life experience. I was on the Second Circuit, and we were dealing with a forfeiture case, and whether or not there should be pre-deprivation hearing or immediate post-deprivation hearings before the police could keep a car, okay? And by the way, the Supreme Court decided that issue later, and they didn't agree with me. But putting that aside, the judge on my panel looked at the litigant and said, why do you need a car in New York City? You have buses, trains, and taxis. And I sort of looked and asked the litigant and said, are there buses, trains, and taxis in New Paltz, New York? Which is a small community about an hour away from the city, okay? And he looked at me and he said, no. There's really a lot of places in New York State where there isn't. And how about, tell me how the person in certain parts of Long Island, where the Long Island Railroad doesn't make it, how they're going to get to work without a car. And so I went on with a few examples like that. That judge ended up agreeing with me at the end, okay? Did that moment have that impact? But I think it took away from his life experience, because he was a born and raised New Yorker, and he wasn't thinking outside of his own life. Does that happen? You know, Justice Ruth Bader Ginsburg in a Fourth Amendment case involving the search of a teenager by her school and whether or not children have some constitutional rights in schools. And my court ultimately said yes. But at the end of that, I remember distinctly being surprised that she told a set of reporters a little bit later that she was surprised and thought that her colleagues, her male colleagues, didn't understand how violative of a personal right it felt to a 13-year-old to have her body touched by a stranger whose permission she didn't give. Now, I don't think the outcome of the case was based on that observation, but I think that none of the opinions in that case spoke as did some of my colleagues in saying that being searched was like going to the gym and taking your clothes off in front of your girlfriends. Nobody wrote that, and that would have been hurtful. So life experiences give you perspectives on issues. If you haven't lived it, it may be hard for you to understand the claims people are making or the impact of what's happening to them. And so that's why a varied life experience, particularly on appellate benches, is so important, because you need those different perspectives. You need people who have lived different lives to sort of understand what people are saying when they come to tell you that something is affecting the quality of their life, and in a meaningful and impactful way. And I hope you understand that these misunderstandings by others are not intentional. And neither is there not understanding what they don't know. None of us know what we don't know. None of us appreciate the full limits of our own vision. Because if you haven't experienced it, how are you going to know? And so I think it's important to recognize that we are limited by just being humans. And that part of what we do as humans is share experiences so that we don't have to experience all the bad for everybody. We share it to try to avoid it for others. We share it to educate. We share it to understand. And sometimes even when you understand, you say, I understand, but I can't do anything about it as a judge. But I think it's better to understand, and it's better to write opinions that doesn't denigrate or minimize the effect on others. That's important too. Because how we write opinions has impact as well. And you can tell people they've lost in certain hurtful ways, or you can try to at least recognize their pain, acknowledge it, and explain why you still need for them to lose. And that's the only thing we can do as human judges, is not to presume that the law is without consequence, or that what we think is right is felt as right by others. Because everybody who loses in a courtroom, guys, feels they lost something. Don't ever forget that. Someone whose a decision has gone against feels that someone has not justified their actions. Someone has told them they don't have a right they thought they had. Someone's told them that they're wrong about something they deeply believed in. That's why they're in court. And when you're doing that, as me as a judge, I know I'm always thinking, not about the winners, but about the losers. Because once I forget them, then I've stopped being a human being. Anyway.
Thank you, Justice. I just want to... Just wanted to say I'm obviously very grateful to be here and wanted to thank you for your generosity and for setting an example for me and everyone here. During my clerkship, I would go into the Supreme Court building every day and would see the words equal justice under law carved in marble. And it's something you think about, it's something that might seem very abstract at first, but it was working for you and working in your chambers that gave those meanings, gave those words a very real meaning, and I am very grateful for that. And I'm sure, like the Dean said, you being here today is going to be a really memorable experience for everyone here. So just thank you, Justice.
Dean, you've gotten a full day of work from me. Thank you all for being here with me today. And I end the way I started. I hope that you, young lawyers in the room, will live a life like mine, filled with purpose and filled with a sense that you're doing good work. Just stay motivated to do it, okay? I expect you to change the world. You have to make a better world than us old fogies have managed. All right? I'm really expecting you to do a better job. So thank you.